today's episode, we talk about the cliff edge many landlords are facing when deciding whether to sell up, the never ending court backlog, and the future of the private rented sector, with our special guest, property litigation partner at law firm Taylor Rose, Patrick Ansell. Thank you so much for joining me today, Patrick. It's great to have you on and to get your expertise around the Renters' Rights Bill. As we know, that's such a huge topic and a really big piece of legislation as well that's set to change the private rented sector. But before we get on to all of that, it would be really nice to hear from yourself how your career in property law first started.
Well, it's started by accident to some extent. I did want to be a solicitor. I studied law and politics at Cardiff University in the early 2000s. I graduated. I spent my first year after university in a manual job while I was trying to work out what I wanted to do longer term, and that probably was what persuaded me to go back to studying. And I did the LPC without a training contract the following year. After I graduated from the LPC, I got a job in a London firm initially on a temporary basis as a debt recovery paralegal. But through that foot in the door, I kind of got taken under the wing of a property litigator. The firm did a mixture of disputes, but there was a quite a large amount of it was property litigation, and I was fortunate to be in the right place at the right time, and hopefully, also reflected my own ability and willingness to learn. I went from paralegal to trainee. And pretty much throughout that time, other than doing the sort of bare minimum non-contentious requirements to get my qualification, I pretty much focused on property lit since then. I was there until 2015 after qualifying, and I've been at Taylor Rose ever since. Well, I say I've been at Taylor Rose ever since. For a short time, I was at what was called Tucker Turner Kingsley Woods, which then merged shortly thereafter in 2015 with Taylor Rose, and I've been part of Taylor Rose in its various developments over that time since, and I'm now a partner in the property litigation team, and almost entirely do property litigation work now.
That sounds really great. And we could definitely use with your expertise around the Renters' Rights Bill. So you seem like the perfect person to ask all these questions to. So my first question is around the abolition of Section 21. As we know, that's a huge piece of legislation in the Renters' Rights Bill. And a lot of landlords in particular are really worried about it. What would you say, in your opinion, is some of the biggest implications that this is going to cause?
Well, obviously, Section 21, as we currently know it, is a no-fault eviction. So landlords have lots of hurdles to overcome to be able to serve a valid Section 21 notice and then bring successful proceedings if the tenant doesn't comply with that notice. But the the essence of it, putting those requirements aside, is that a landlord can evict for any reason they want. They don't have to give a reason, essentially. It might be in the background that they don't like the tenant, or it might be that they want to use the property for some other purpose, to sell it, to whatever, to do whatever they like. They could just wake up one morning and decide that they don't want to be a landlord anymore, or they're going to gift the property or whatever. But that process that we've been familiar with for, well, certainly throughout my career and for quite a while before that, has enabled landlords to have that flexibility outside of any fixed term. And the abolition is going to be something which is going to be difficult for a lot of people to get their heads around. I think there are obviously much wider changes in the Renters' Rights Bill, but the changes that they're making to what we currently know as Section 8 which sometimes gets forgotten about because landlords go straight for Section 21 because it's often seen as the easiest option. The expanded Section 8 is going to hopefully take a bit of the uh, the changes won't be as bad, if I can put it that way, for landlords as they would otherwise be without these changes to Section 8. And hopefully, a lot of the reasons that a landlord might have for wanting to get their property back will be covered by Section 8. Certainly, there isn't a ground for I don't like my tenant, but I don't have any other good reason for it. I don't like the look of them or what have you. Um, or they're a bit annoying, but not quite annoying enough for it to meet any of the other grounds. But the position is all of the legitimate reasons a landlord, or most of the legitimate reasons a landlord might want their property back, will be covered in the expanded Section 8. So wanting to sell the property, wanting to move in are two of the obvious ones.
Yeah, exactly. And I think it's just important to say as well, like, as you were touching on there are definitely some bad landlords out there in the sector, there's no question, but the majority of landlords are really, really good and they want to look after their tenants for sure. And also, as well, with the court capacity as well, that's going to be a huge implication because of Section 21 being abolished. As we know, there's a huge, huge court backlog at the moment. Are you seeing that for yourself as well?
Yes, I mean, most landlords may be geographically placed, obviously, other than the very big ones, which may have properties all over the place. Most landlords may have one or two properties in a given area, and they might be quite close to each other. So their experience might be with a particular county court. Now, the general picture is that the county courts, as the wider judiciary and court uh, capacity in other areas is stretched and has been stretched for many years. And certainly this legislation isn't going to make it get any better. Things are worse in some places than others. The the court rules, or the CPR, essentially the guidance is that the first hearing in any possession claim, other than trespassers, I believe, is meant to be within 4 weeks. Well, sorry, not sooner than 4 weeks of issuing the claim, but not more than 8 weeks. So that's the window that they're aiming for. Most cases will just about get that first hearing will be inside that 8 week period, but certainly not all the time. I had an example, I won't say which county court specifically, but in a county court in the north of England, where we issued a claim at the end of June last year. And the hearing wasn't until the 1st of November. So essentially, that was slightly over 4 months. So we had a landlord client who was essentially hadn't received rent. That was the reason that they'd issued the claim in the first place. And they had a further period of 4 months until that first hearing when they had essentially an open and shut rent arrears hearing, possession order made. And then obviously, had to then wait for possession thereafter. So it's not this new regime isn't going to make it any better. I think particularly what some people might be familiar with is obviously under Section 21, you've got what's called the accelerated procedure. Now that's a slight misnomer. It's not always quicker, but generally speaking, it's quicker because you don't have a court hearing if the court is satisfied that the paperwork is all in order, and they can make an order on the papers. Now that, as things stand, isn't going to be an option. There isn't a revamped accelerated procedure in the new legislation. So every case where the tenant doesn't just receive the notice and walk away from the property of their own free will is going to require a hearing, and as you've alluded to, it will put more pressure on the courts.
Exactly. There seems to be a lot of pressure on the courts at the moment. And as you just highlighted one of your cases there, taking 4 months, we get a lot of comments on the Property 118 website saying the exact same thing, that it's taking months and months and months. And of course, the landlord in the meantime isn't getting any rental income whatsoever. So that's causing a huge knock-on effect. And because of this, a lot of landlords are just saying, I've had enough, I'm fed up, and just want to get out of the private rented sector. Are you seeing that as well from your perspective? Are you getting landlord clients saying to you, I've just had enough and want to leave the sector?
I think anecdotally, that is something that seems to be a concern for people in the property industry and landlords that I've spoken to. I think in terms of volumes of the cases that we deal with, it's not necessarily borne out by those at the moment. So whilst, when we meet landlords, they say it's not worth being a landlord anymore. The tax, the tax rules aren't helpful. There's too much power being given to tenants. I'm not going to be able to evict if I need my property back. I don't think I want to be a landlord anymore. Whilst we do have those conversations, I think at the moment we're not getting certainly within our team, we're not getting a glut of landlords saying I'm selling up because of the Renters' Rights Bill. Now, it might be that those landlords with one or two properties who have either inherited them or have moved in with a partner and they've got a second property for that reason, or it's their nest egg for retirement or whatever. It might be that those people, when the full impact of the Renters' Rights Bill, which may not yet have dawned on them, and it might not dawn on them until they have a bad experience, if they do have a bad experience when it becomes law, that might trigger them. It may also be when we know exactly when uh, the bill has had royal assent and when it's all going to be rolled out thereafter, and we know the exact sort of final wording. It might be that that's the kind of thing that pushes these people who are on the edge of the cliff at the moment and thinking about selling up. It might be that which makes them think, well, it's now or never. I'm gonna serve Section 21 while I still can. But at the moment, we haven't had that sort of looking for another metaphor. We haven't had that sort of avalanche of landlords doing that. Although, in the background, I suspect some are thinking about it, or maybe a lot are thinking about it.
Exactly, as you were saying there. I think at the moment there's like a combination of things going on, as you were saying, to do with the Section 24 tax as well. And then, as you say, there's some landlords at a cliff edge that are thinking, oh, seeing what's going to happen at the moment. As you touched on there, obviously, the Renters' Rights Bill hasn't become law yet. I think, correct me if I'm wrong, but they're looking at sort of summertime. I think that it might see royal assent.
Yeah, I mean, I think that seems to fit with the passage through Parliament. There's obviously an impetus to get this over the line. It's sort of one of the sort of flagship policies of the new government. The Obviously the difference between royal assent and sort of commencement date is obviously slightly different, and the government have been sort of fairly vague about when it's actually all going to take effect. They've sort of said that reasonable notice will be given, but whether reasonable notice is, a landlord and a tenant will have different perspectives on what reasonable notice will be in this thing. I mean, I would be expecting it to be um, this whole new world, this whole new regime to be, we'll be dealing with it by the end of the year, and I do expect it to be um, given royal assent, probably by the middle part of this year. But when it actually, um, fully takes effect, that remains to be seen. And obviously, the more information that can be provided in advance notice, the better for everyone.
Definitely, definitely. Because at the moment, I think I know it's in the House of Lords, but I think it's around the committee stage. So obviously, we're still getting some of the amendments coming through. So whether we'll see what eventually happens with the Renters' Rights Bill, but it seems that, as you said, that a lot of landlords are just waiting to see what happens with that. And you were touching on earlier about the Section 8s for the possession grounds. So obviously the Labour government are looking at that for the Renters' Rights Bill. So for a landlord watching right now and they're thinking, oh, if I need to, for example, evict a tenant because of antisocial behaviour or they're not paying rent, then what are going to be, what do we know so far about the new grounds for the in the Renters' Rights Bill?
So a lot of the grounds will either be the same or very similar to ones that are already in there. Some of them are just beefed up versions of what's already there. Um, when we're advising landlords, often we'll get approached by landlords and they've got an issue with a tenant, and we will work out that for one reason or another they can't serve a Section 21 notice, even under the current rules. So whether that's because they're still in the fixed term of the tenancy and it's not expiring anytime soon, or because it may be no fault of the current landlord. They may have inherited a property from someone else or purchased a property, and there's been some underlying issue with the paperwork, and they can't serve, or would be very difficult to serve a valid Section 21 notice. So they're looking at Section 8. Now, what we would often say, or generally say, is that you've got this huge menu of grounds, and it will be even bigger under the new legislation. But obviously, some of them are discretionary, as some of them are mandatory. We would rarely, I wouldn't say never, but we would rarely be recommending to a landlord client to proceed with a discretionary ground, just because that obviously gives the the judge the final say in whether possession should be granted, even if the landlord has done everything correctly procedurally. The mandatory grounds are the ones that you really want to be relying on. In terms of going back to your question about antisocial behaviour, under the new rules, there'll be two specific grounds relating to antisocial behaviour. One of them is a mandatory ground which relates to serious antisocial behaviour, and the other one is a discretionary ground which relates to sort of, more run-of-the-mill antisocial behaviour, if I can put it that way. But certainly anything below that serious uh, um, definition. Now, when you dig into what is serious antisocial behaviour, or serious offences as well, we're essentially the main way of doing that will be to prove that the the tenant has committed some kind of serious offence, or there's been some kind of serious incident involving the property, and or the someone who resides at the property with them. Now, that will be good reason in certain circumstances, but we don't see a huge amount of landlords coming to us at the moment with antisocial behaviour issues being the reason that they want to evict. I mean, it's generally the obvious ones, rent arrears and things like that. So turning to rent arrears, the the grounds for evicting someone under rent arrears aren't really going to change much at all. The time frames are going to change, but the actual procedure isn't going to be much different. So under the new ground 8, so Section 8 ground 8 would be a mandatory ground for possession. You would need to have a tenant who's in 3 months rent arrears when you serve a notice, and you would then need to give them 4 weeks notice. So at the moment, you give them 2 weeks notice when they're in a minimum of 2 months arrears. So you're going to need at least 3 months arrears and give them 4 weeks notice. And then you have to at the relevant. So if they haven't obviously paid up the rent to bring it below that limit, you can issue a claim after expiry of the notice. So at the point of issuing your claim, you also need to have a minimum of 3 months rent arrears, and then again, if it gets to a possession hearing, you still need to have that 3 months minimum at the time. Now, some people have sort of mentioned about people playing the system. I mean, that kind of exists now. If you're in 2 months rent arrears and you get served with a Section 8 notice, you can pay a small proportion of your rent to bring it below that 2 months, or what will be 3 months requirement, to frustrate that notice. So that will still be there, but in reality, most people don't stop paying the rent for no reason. It's usually due to lack of money, due to whether that's for employment or some other reason. And um, you know, usually the reason people aren't paying is because they can't afford it, not because they're just putting the money in the bank account and leaving it there, but thinking, well, I'll pay it to the landlord when I really have to.
Yeah, that's some really helpful advice there, particularly with the possession grounds, because it can be like a little bit confusing, particularly like for some landlords, because there's a lot of rules and regulations that landlords have to follow. You might know about more this than me, but I think isn't it like landlords have to follow something like 300 or something rules and regulations, something like that?
Well, I certainly haven't added them up, but I don't think you'd be far off. If I was making a guess, I might say 100, but I'm sure someone has added them all up. Certainly over the course of my career, there's never really been a reduction, an obvious reduction in the requirements a landlord has to do. The first one I can remember when I started working in this field was when they started making people register their deposits, and everyone was up in arms about that. And in reality, it's probably been a good thing. And then obviously we got gas safety rules, HMO, selective licensing, and I'm just trying to think off the top of my head, how to rent guides, and all sorts of things which landlords can trip up on, and often it might seem quite trivial, and sometimes it can be fatal even under the current rules to doing a Section 21 notice.
Mm,
So yeah, I mean you know the fact is that being a landlord isn't an easy task, certainly for someone who's not got experience of it. And it wasn't really directly related to your question, but I think my view would be, if you end up as an accidental landlord, or a landlord without any sort of great experience, I think getting I mean, hopefully you won't need someone like me, but certainly not at the outset. But getting a good local agent's often the key to making sure that you can maneuver your way through all of this legislation and all of the rules you need to comply with.
definitely, definitely. Because I think particularly if you're self-managing a property, I don't know how some landlords do it because there's just so many rules and regulations to follow. And as you say, with a letting agent, that can be really, really good to have. And I wanted to ask you as well. We had an article on Property Woman 8 I think a few months ago now, but it was about the government was looking at banning rent in advance payments. Now, this could cause actually really big implications because obviously, if you're, for example, a landlord that's renting out to international students, then a lot of international students actually pay the rent up front in order to secure the property, and for the landlord, it provides security guarantees as well. But the government have hinted that they're actually looking at thinking of getting rid of that altogether. And there was a hint from the government that they might actually be looking at issuing fines for landlords because if landlords do rent in advance. What do we know about this?
So the amendments. So obviously, as you've been talking about the passage through Parliament, it had a reading in January, and one of the amendments that was introduced in January was a ban, for want of a better word, a prohibition on upfront rent payments. I think I think it's over 1 month rent, or if you're paying your rent weekly, for example, it would be a maximum of 28 days up front. So I can see the issue that in certain circumstances, landlords or indeed tenants may actually prefer this. I mean, even domestic students might get their student loan once a term. And certainly I can think back to my days. I think we used to, get our student loan on, Monday or the first day of term or whatever it was. And we were writing a check. That probably shows my age as well. We were writing a check to the landlords, probably the same day, and he was coming around to collect them all. And that was our terms rent paid up front, and that wouldn't be allowed with this change. Um, the rationale, I guess, is to some extent, and we do see it even outside of the sort of student accommodation sector. We do sometimes see tenants who've paid, say, 6 months or even 12 months rent up front. Now, a tenant might have reasons they want to do that, like, well, I've got the money now, I might not have it in 12 months' time. The type of work I do is, if they're employed, the type of work I do, I'm self-employed, I've had a great deal recently. I can afford my year's rent now, but, I might be not in such a great position in 3 or 6 months' time. They might not have a good credit history. There's lots of reasons why it could be justified from either the landlord or the tenant's perspective, but ultimately it is a bit of a backdoor to um, getting more money up front when you can't get deposits that are as large as they used to be. In the past, you could get, a 3 month security deposit, and then the need for asking for rent up front wouldn't necessarily be created. So I think the workaround is going to be something like, there'll be more guarantees, or, requirements. Landlords will be requiring, guarantors to stump up money. If students are international, then I would imagine that those guarantors are going to have to be people or entities based in the United Kingdom, just for the ability to recover. The alternatives are obviously landlords can get insurance for non-payment of rent to protect them, or there are, I believe, some professional guarantor schemes. I'm not entirely familiar with how those schemes work, but there are there are workarounds, if I can put it that way. But certainly from what I've read, there didn't seem to be any indication that this requirement for a limit on maximum of 1 month up front was going to be that student accommodation was going to be excluded from it. So it does seem it will apply to everyone. What I should say is I don't think it will apply to university halls of residence. We're talking private rental accommodation, which is occupied by students.
Yes, yeah, thank you for that because obviously there is a difference there, so it will affect private rented sector. And yeah, as you were touching on there about the guarantors as well, particularly as well if you're an international student, it could be quite tricky to find a UK-based guarantor. So that's a huge issue as well. Now we're coming to the end now, but I know it's a big question to ask, but what do you think of the future of the private rented sector?
Good question. Difficult one to answer. I don't have a crystal ball. There will always be a demand for private rental properties, and I suspect that things will settle down after the legislation comes in. I'm sure that there will be some landlords who um, either when or immediately before the legislation comes in decide that they've had enough. There'll be some landlords who think, well, I'll give it a go under this new regime, and it might be when they have a bad experience trying to evict a tenant, they think, well, enough's enough, I'm off. The ultimate problem in the rental sector, or not the only, but one of the main problems is obviously the lack of lack of rental stock. That's why rents are high, and lots of bad landlords can get away with being bad landlords because there isn't enough out there. Now, what we don't want is for landlords to walk away, and if they're not replaced by someone else who wants to be a landlord, then that may end up with a new uh, privately owned property on the market which wouldn't have otherwise been there. So that could be seen as a pro, but obviously the con is that's one less property in that area that's being used for private rental accommodation, which there's always going to be a demand for. So it's very difficult to make changes which don't have some kind of knock-on effect which is a negative impact. I think we'll just have to watch this space really. But I think this is the biggest change for a generation in terms of private rentals. But as history has shown, there will always be a problem to fix, and so the next change is in 5 years' time or 10 years' time probably won't be as drastic as this, but they probably will need to be adjustments to rectify any unwanted repercussions of what's going to happen.
Exactly. Well, we will have to watch this space and see what happens. As you say, the supply and demand is such a huge, huge issue. And if we're getting all these good landlords leaving, and if they're not being replaced by good landlords, then of course that is not going to be good for anyone. But as we say, let's watch this space and see what the government does. Well, thank you so much, Patrick, for coming on today. It was really interesting to chat to you and some really helpful advice there, particularly with the possession grounds for landlords. So thank you so much for joining me today, Patrick. Great to have you on.
Pleasure. Thank you very much.